Hello everyone, I am Ansh and this is Adimesh. We are members of the dispute resolution team of Nishith Desai Associates, and in this video we'll be discussing various timelines and limitation periods for filing various petitions and applications under Indian law with reference to the Indian Arbitration and Conciliation Act of 1996. So Adimesh, tell me when disputes first arise between parties and when they want to seek an appointment of an arbitrator or an arbitral tribunal, they have to approach the court under Section 11 of the Arbitration and Conciliation Act. What is the time period in which they should do so?
Yes, Ansh. So the timeline for filing a Section 11 is although not prescribed in the Arbitration and Conciliation Act, but we've had a series of judgments from the Supreme Court which have discussed the timeline for filing an application under Section 11. Now the Section 11 prescribes, or these judgments rather, prescribe a timeline for 3 years for filing an application under Section 11. Now the question arises, when does this timeline of 3 years begin? The judgments have said that the timeline begins on the date on which the right to sue accrues. Now we have another judgment of the Supreme Court which has now recently explained the phrase as to what the right to sue accrues means, or when is the right to sue accruing. This phrase has now been explained to mean the date of commencement of arbitration, and as we know, the Arbitration Act provides for a stage of commencement of arbitration which is nothing but the issuance of the notice of arbitration. So effectively, the timeline for filing an application for seeking appointment of an arbitrator under Section 11 is 3 years from the notice of arbitration.
Understood. So in what period should parties apply to set aside an arbitral award? I understand Section 34 of the Arbitration Act deals with this.
Correct. So as opposed to Section 11, Section 34 does provide a timeline for filing an application for setting aside the award. The timeline provided in this regard is 90 days from the date on which the award is received by the party. The section also provides for an extension of 30 days if the party is able to prove that the party was unable to, or circumstances existed which prevented the party from filing a Section 34 within that period of 90 days. Now the extension is 30 days. So effectively the cumulative period for filing the Section 34 is 90 plus 30 or 120 days.
Got it. So now let's talk about Section 37 of the Arbitration Act. Section 37 deals with filing of an appeal in relation to certain orders related to the arbitration proceedings. What are the timelines associated with that? Okay,
so Section 37 provides for filing an appeal. Now these appeals can be in cases which are a commercial dispute or in cases which are not a commercial dispute. Now under the Commercial Courts Act, the definition of commercial matters or commercial suits is said to be matters which are above the specified value of 3 lakhs. So for these matters which are commercial matters, the timeline provided for an appeal under 37 is 60 days from the date of the order under challenge.
Understood. So now let's move on to Part 2 of the Arbitration and Conciliation Act. What are the timelines associated with enforcement of a foreign award under Section 47? And is there a distinction between the timelines associated with enforcement of a domestic award and an enforcement of a foreign award?
So definitely there is a distinction between the timeline for enforcing a domestic award and enforcing a foreign award. Now the scheme that is provided in the Arbitration Act for enforcement of a foreign award is that the foreign award must undergo a stage of recognition and enforcement before the foreign award is actually executed, as opposed to a domestic award which is understood and actually defined to mean a court decree under the Arbitration and Conciliation Act. Now because the domestic award is considered to be a court decree already under the Arbitration and Conciliation Act, therefore the timeline for executing a domestic award is 12 years as per the Limitation Act, and which is akin to any other court decree under the CPC. Now when we come back to talk about the foreign award, because the foreign award needs to undergo that process of recognition and enforcement, the timeline for filing this petition for recognition and enforcement is 3 years, as has been decided by a series of judgments, including the landmark judgment of the Supreme Court in Vedanta International.
Thank you, Adimesh. This was really helpful. We hope this provides much needed clarity on filing various petitions and applications in relation to the Indian Arbitration and Conciliation Act of 1996. We hope you find this useful.
Thank you.